Good morning, everyone, and thank you for the ADMS Compliance Webinar Wednesday. You should be able to see my computer screen and the PPT presentation on your computer. If you can view that screen, please let me know. Those of you who are listening in for the compliance webinar via phone, I would ask you to please put your phone on mute because we're catching some background conversations and conversations including protected health information. For those of you who are listening on your phone, if you'd be so kind to please put your phone on mute, we're hearing background conversations. Thank you. Well, thank you, everyone, and welcome again to ADMS Compliance Webinar Wednesday. Today is August 31st, 2016, and we're going to talk about some of the legal and regulatory effects that dictate and address how we work within the workplace here. Now, as in the past, let me introduce the Office of Compliance and Regulatory Affairs staff. There's William D. Cundiff, Ricardo Sime, and Alexander Osorio. Please note that the terms Atlantic Dialysis Management Service and ADMS in this program refers both to those specific organizations as well as to its contracted network of affiliated dialysis centers and physician practice locations. So let's start right off with the Stark Act. And the Stark Act falls under 42 U.S. Code 1395. And we're going to go into each of these definitions that you see highlighted and italicized in red in a little bit detail so you have an understanding. The Stark Act is very important in the way we operate dialysis centers. Once again, someone has their phone. If you can mute your phone, please. Thank you. So the Stark Act prohibits a physician from making a referral to an entity for the furnishing of a DHS, and DHS stands for a Designated Health Service, for which payment may be made under Medicare if the physician or an immediate family member of the physician has a financial relationship with the entity. And we'll go through each of those definitions. So again, Stark Act, and you may hear this during the course of conversations, whether employed at Atlantic Dialysis Management Services, any of its dialysis centers, or those of you who work in another organization as well, may hear conversations regarding Stark and Stark Act and Stark exceptions. So it prohibits a physician from making any referrals to an entity for any of the designated health services in which they can receive payment from Medicare if either the physician, him or herself, or an immediate family member has a financial relationship with the entity. And we're going to address each one of those here. So in Stark Act, in some situations, as you know, there has to be a proof of intent, a proof of malice. In situations involving the Stark Act, there is no proof of intent required. As we've talked about in compliance, perception is reality. So what's a simple example of a Stark Act? Well, in terms of a Stark Act, if Dr. X owns a practice and he refers a patient to have lab work done by a lab that's owned by Dr. X, that would fall under the Stark Act definition.
All right, I hear him.
If you can mute your phone, please, because thank you for hearing me. We just don't want to hear your conversations. No offense. Thank you. So who are physicians and who are immediate family members? Well, physicians are defined under the Stark Act at 42 U.S. Code 1395 as either a medical doctor, a DO, a dentist, a podiatrist, an optometrist, or a chiropractor. Immediate family members are exactly that, immediate family members. It could be the husband or wife or a doctor, the birth or an adoptive child, siblings, a step-parent, a stepchild, a stepbrother, stepsister, your in-laws, father-in-law, mother-in-law, your son-in-law, your daughter-in-law, your brother-in-law, your sister-in-law, any grandchildren or grandparents, and also any spouses of any grandparents or grandchildren. So Stark law is written very, very broadly to encompass a number. So what's a referral defined as? So a referral is defined as the request for an item or a service by a physician. Okay? Or it's the request by a physician in consultation with another physician for any tests or procedures the physician orders or he or she performs or supervises. Folks, again, I'm going to ask you if you can mute your phone, please. We're hearing background noise and paper. Thank you. A referral also includes the request for a plan of care that includes the use or provision of any DHS or designated health services. So what isn't a referral? A referral is any services that personally performed by a referring physician. Instead of you referring the patient to seek care or services somewhere else, the physician is actually providing the service on his or her own self, or the services are requested by a pathologist, a radiologist, or a radiation oncologist pursuant to a consultation. And again, that doesn't apply to us per se, but I wanted to make sure everyone was aware of some of the definitions of a referral. So what's a designated health service or a DHS entity? And pretty simple, the statute is written in such a manner that the DHS is an entity that either bills for the services or an entity that either performs the services. And from a compliance perspective, that's an important item to be aware of. So what do DHS include? Well, it includes a number of different items, and you'll see the note at the bottom of the page as it applies to dialysis, but a DHS could include lab services, PT or OT services, certain items of radiology or other diagnostic services like MRIs or CAT scans, radiation therapy, DME, certain nutrients, equipment or supplies, prosthetics, certain home health services, outpatient drugs, and certain inpatient and outpatient hospital services. Do note that services provided by dialysis facilities or outpatient dialysis facilities do not fall under Stark's DHS definition, and that certain drugs administered by dialysis facilities, do fall under the exceptions. So that's a definition of referrals, DHS entities, and other items. What about from the financial relationship? Well, the financial relationship really is defined as any payment or other benefit made directly or indirectly in cash or in kind. So it doesn't need to be cash. It could be tickets. It could be use of a car, use of a home, vacations. It doesn't need to be cash in terms of a definition of a financial relationship. So, and a financial relationship could be certain things like an ownership interest. Okay. Again, folks, I'm going to ask you if you can mute your phone, please, if you're listening in the background. Thank you. Or it could be compensation such as direct or indirect, as we talked about, medical director agreements. Use of lease agreements will make you a consultant. Medical service agreements or certain types of personal service contracts. So it could also be items such as payments for services, using space, maybe using staff personnel, CME programs. One item we talk about, financial relationship, and you may be aware of some of the ADMS policies as it applies to it, lunches being given with respect to trainings and in-services, could be dinners, certain levels of trinkets, and in some situations the courts have found that free parking or parking at a reduced cost, it also falls under the definition of a financial relationship. So some of the exceptions where the items do not become illegal. Folks, if you can please mute your phone. Thank you. So if a financial relationship exists with an entity and those patients are being referred for DHS, then the activity either has to comply with one of the exceptions that we'll show, or the activity is going to be deemed to be illegal. So what are some of the exceptions? Well, some of the permitted ownership and compensation arrangements are if it's for physician services, if it's for in-office services, services to members who are members of prepaid health plans, arrangements as it applies to academic medical services, implants furnished by ambulatory surgery centers, dialysis-related drugs furnished by end-stage renal disease facilities, such as ADMS affiliates, preventive screening tests and immunizations, and then eyeglasses and contact lenses following certain types of surgeries, and then for more of the rural areas, intra-family rural referrals. And those are referrals, obviously, based upon distance and where people live in some of the more rural areas. Certain exceptions are permitted because there's not a large number in some locations of healthcare providers. Other exceptions are permitted ownership interest where publicly traded securities or investments in mutual funds. Again, a rural provider, if the provider provides 75% of the designated health services to residents in these rural communities. Certain hospitals in Puerto Rico, and then a hospital ownership in whole, but not a department or a floor. Some of the other permitted compensation arrangements under Stark are rental at fair market value for office space, the rental of equipment, employment relationships. Again, these are all at full fair market value rates and contractual arm length. Personal service arrangements or physician recruitments, services related to provision of DHS, certain hospital-affiliated group practice arrangements, and also some certain fair market value payments made to physicians for items and services like clinical lab services. Other exceptions that are, folks, if you can mute your phone, please. We're getting your conversation in the background. Folks, those of you who are talking in the background, can you please mute your phone? Mute your phone, please. We'll continue, folks. Hopefully when the person who's typing on their keyboard hears us, they'll mute their phone. So permitted compensation arrangements would be any charitable donations by doctors, non-monetary compensation benefits up to $300 per year, any fair market value compensation, any incidental benefits that come with medical staff, any risk-sharing arrangements, obviously compensation as it applies to doing compliance training by outside vendors, any indirect compensation arrangements, and certain referral services are also going to fall under the exceptions. Let's bypass that one here. Under medical director compensation, under Stark, the financial relationship is defined as an ownership or investment interest in or a compensation arrangement with an entity providing DHS and includes certain indirect financial relationships. And this becomes an important area of play to be aware of as it applies with the medical directors in each of the regulated dialysis facilities under Atlantic Dialysis Management Services. While it's believed that compensation under our agreements are the result of arm's length negotiation, results in fair market value payments from medical directors, of course, any enforcement agency could nevertheless challenge the amount of compensation that's paid to our medical directors, but we do keep that in line. Everyone does have a fixed amount that's not based upon the number of patients seen, number of treatments occurred, number of dollars of revenue or expenses we have or don't have. So compensation is fixed, and each of the medical directors are required to put in a certain number of hours each month in terms of providing medical director services to the dialysis centers, the employees, and the patients. So the anti-kickback statute, which also falls under 42 U.S. Code, but Section 1320, really prohibits payments to get federal health care program business. And again, this is a situation of referrals. Now, where we talked about the Stark Law did not require any intent, in the anti-kickback statute, there is a criminal statute that talks about intent. So in kickback statute, intent matters. In the Stark Law, intent is not requirement. So in the anti-kickback statute, the result could be that either you're in jail, you could face criminal fines, or in some situations you may be subject to both. If it comes into civil monetary penalties, right now it's $50,000 per kickback, plus 3 times the amount that's being repaid. You could also suffer and fall under the exclusionary list, which means you'll be unable to participate and receive funds on either the federal Medicare or Medicaid program. And those of you who have been with the organization a while and have gone through the compliance training realize that the ADMS Compliance Department with the facility administrators / center compliance officers conducts monthly background checks of all employees, all consultants, all vendors, all privileged staff members to ensure that no one is on any of the exclusionary lists. And also under the kickback statute, you would face liability, or the organization could face liability under the False Claims Act. and we'll talk about that in a little while. So what to look for when we're doing an anti-kickback analysis in the compliance office? Well, first thing we look at is to see whether or not there's any financial arrangement or any non-cash inducement between the party that has referrals and the party that wants them. No, so is there money being exchanged, or if it's not money, is there something else being exchanged between the two people, one who has a referral and the other physician or the other healthcare provider who wants a referral? Again, you want to look at what the level of compensation is, and then you want to see whether or not the money follows the referrals. Now, certain protections that fall under the kickback statute are also under the 42 code. And some of the common features are, if we go to bullet point 2 and 3, obviously, is to make sure that there is a written agreement signed by both of the parties that has at least a minimum 1-year term, and that the compensation is fixed and set in advance, that the compensation is not tied to something to be determined in the future, as we've talked about, the number of patients to be seen, the number of patients to be treated, the amount of revenue to be made, the amount of expenses to be saved. So the agreement has to be tied to a set amount in advance, and the services to be provided under the anti-kickback statute, the actual services has to be very, very direct and very straightforward in what needs to be offered. And the benchmark that we generally use in this situation is, what is the current fair market value? Because if things are being done at a certain price point, either above or below the fair market value, it may gain some interest by the outside regulatory agencies to determine whether or not there is a kickback involved. So fair market value, what is the actual determination on the street as to what these services will cost, will be indicative of whether or not it falls in under the anti-kickback statute. So some of the practical tips. Well, first thing we're always do is, obviously, is be concerned about the relationships of individuals. Are they owners? Are they friends? What's the relationship? Personal relationships, family and friends. So we are concerned about relationships about the anti-kickback statute, the AKS. And right now in compliance, the big focus is between hospital and physician relationships, and those are really the prime source these days in the compliance departments, the Inspector General Office, and the Department of Justice, as they're looking at anti-kickback statute problems. So how do we control this? Well, really the control falls over the contracting process for these relationships. How does contracting occur? And that's why individuals, our contractual review process, the purchasing and management process by Richard Tagliagambe and his staff become very important to look at in terms of anti-kickback statutes. And actually we had a meeting about some of this morning. So we have to make sure that there's a policy governing about how the contracts between the facilities must be processed. And then they'll also have checklists in place to determine whether or not, what is the specific business purpose that the relationship is trying to achieve, and is the payments being made, are those payments falling within a fair market value scenario? And those are some of the practical tips as it applies to the AKS. Now, some of the penalties we talked about under Stark, strict liability, as we talked about, intent is not a requirement. So some of the penalties could be maybe possibly a denial for payment for services provided. There could be a request that refunds are made, or requests for refunds are made from the amounts that have already been paid out. The following numbers could be changed, but there could be civil monetary penalties up to $15,000 for each referral, and then up to $100,000 for each scheme. And right now, those numbers are about to change and going to increase based upon inflation. Once again, we talked about there can also be exclusion from either the federal Medicare or the state Medicaid program, or there could be one of the penalties could fall under the potential under the False Claims Act, and it could be liability that falls under the FCA or False Claims Act. So when looking at this, what are some of the decision tree items that come into play? So the first question you want to ask yourself is, was a referral made? So it's yes, no. And the answer is, if the answer is no, if there was a referral made and there was no referral in the decision tree, then the response would say, you know what, no, then go ahead, you can do the deal. Subject to other items, but you can do the deal. So, but if the question is, are there referrals being made, and the answer is yes, well then we would go on to step 2. And step 2 would be, is there a DHS or a designated health service involved? And if the question is no in the contracting scheme, then again, the recommendation would be fine. Go ahead and do the deal. But if we do find out that there is a designated health service involved in the decision, then yes, we have to then go, let's go to the next step and do our next level of analysis. So we would go on to step 3. And step 3 would be is the person or the organization who's going to be receiving referrals a designated health service entity? And if it's not someone who provides designated health services or a healthcare provider, and the answer is no, then our recommendation is going to be go ahead, do the deal. But if the answer is yes, that the recipient is going to be a referral, the recipient of the referral, pardon me, is going to be an entity for designated health services, then the answer is yes. Let's go on to step 4 and the next question we ask ourselves. And the next question is there a financial relationship? Is there some level of ownership between the parties? Is there some compensation to be exchanged between the parties? Does that exist? And if the answer is no, then we're going to say go ahead, do the deal. But if the answer is yes, then we're going to take it another step further and go on to step 5 before we're able to render a decision. And the next question 5 is, does the relationship qualify in all respects to any of the exceptions that we discussed earlier? Okay? And if the answer is no, then our decision is going to be don't do the deal. But if we do find, based upon any of the exceptions we talked about earlier in the presentation, that there is an exception to the presentation and we can justify it and it can be documented, then our recommendation is going to be yes, do the deal. So from a penalty perspective, again, we've talked about the penalty could be a denial of payments for services provided. Once again, it could be a claim for refund, a claim of refund for the monies provided. There could be civil monetary penalties up to $100,000. And again, you could be excluded from either the federal and state programs, Medicare and Medicaid, for any improper claims made or any schemes. And that up to $100,000 and $15,000 is per claim made, not a total for a whole bunch of claims. So if there is a scheme or series of claims made, that could be a dollar value for each of the claims made that fall in violation of the stock law or the anti-kickback statute. Let's talk about leases, and leases become important in some of these situations. So some of the dialysis centers are actually leased from entities in which referring physicians hold interests, and then we sublease some space to referring physicians at some of our dialysis centers. Under stock law, there is an exception for lease arrangements if the requirements are met. And we believe that all of our leases with referring physicians materially satisfy the requirements for this exception. And that was something someone had raised in the course of conversation as we were preparing the presentation for today was, what about the lease agreements? So the lease agreements for the dialysis centers do fall under the exception matter. So generally to the stock law, the exceptions, once again, just to follow, there are 3 types of exceptions. One is for ownership or investment interests. One are based upon certain compensation arrangements, and I give you the code references there for those of you who are in college or in law school doing some studies. And then for certain level of services, which are applicable to both ownership, investment, and compensation enrichments. Other exceptions fall upon whether or not there's knowledge for payments made, and then certain exceptions also fall into play for temporary non-compliance scenarios, but that's a little bit too deep for our conversation today. Some of the practical tips, again, it's a relationship-based problem. As you see, or as you had seen from some of the steps we made, there's a multi-step approach that we undertake, a 5 or 6-step approach. So it's really a relationship-based problem as it applies to stock. And some of the practical solutions that we deal with are pretty much the same as we deal with in the anti-kickback statute analysis. The key is to have control over our contracting process and making sure that we have appropriate policies in place and appropriate and checklists in place. And also that there's a control over accounts payable to ensure that checks are cut only when there is an appropriate level of documentation. And that's reviewed on occasion through the annual audit plans that we have in place. Let's talk about some self-disclosure protocol as it applies to the Office of the Inspector General from the Department of Health and Human Services. So in certain cases when there's a stock law violation, anti-kickback statutes, and we identify it, we're required to do a self-disclosure. So if we find that there is an item that's in violation and we have to do a disclosure, where do we make that disclosure to? Well, we would disclose to the Office of the the Office of the Inspector General for Health and Human Services only when there's a potential fraud against federal health care programs, which is more than just an overpayment. So it's fraud, not overpayment. We would make a disclosure to the Center for Medicare and Medicaid Services, to CMS, when there was a violation of a stock law. We would disclose to any of our contractors or our RACs when there's an overpayment. We would apply to the state also based upon certain state laws, and the same thing to the U.S. Attorney's Office, again, based upon violations of certain federal and state laws. The self-disclosure protocol falls under Section 1877 of the Social Security Act, and it looks like in total there's been to date about over 300 disclosures, and from those disclosures of self-disclosure, 29 have actually been published settlements, and if anyone wants to contact me, I can get you information regarding the website. And the disclosures that are made by CMS are organized with complete legal and financial analysis and provides a whole series of supporting information and documentation for those of you interested. So some of the summaries of stock, well, be aware again, there's civil penalties. Okay, it's a civil penalty situation versus the anti-kickback statute, which could be criminal. Again, the focus is on relationships, and the relationship again is based upon referrals from one service or provider to another, that the services referral is being made for a certain level of DHS, that there's a financial relationship involved, and again, be aware of the fact that some of the relationships extend past the physician, him or herself, to his or her individual family members. Stock summary also, there's qualifications for certain exceptions, and more importantly, just be aware of certain items. There are some violations of liabilities as it applies to the False Claim Act. For detailed information or more information about this presentation or any other presentations, or if you'd like us, the ADMS Compliance Department, to come to your location and discuss this or any other part of our compliance program, please call the ADMS Compliance Office. That number is 718-483-7428. Once again, the ADMS Compliance Office can be reached at 718-483-7428. Our next webinar Wednesday coming up for compliance training is going to be scheduled for September 28th at 11 a.m. Our topic on that day is our email encryption system and why we have it and why it's not a negotiable subject of discussion. So with that being said, we're going to open up here for any questions anyone may have. You can either, my suggestion is, if you're on the computer, in the lower right-hand corner, you'll see a chat box, and type your question there, and then we'll attempt to respond. So thank you, everyone, for joining. Also, for everyone to be aware, this conversation and presentation is being recorded. It will be posted on the ADMS website on the About Us section. If you click on ADMS Webinars in the About Us tab, and it will bring you to the website. Currently, we have the May and June presentations there. The July presentation still hasn't been posted by our web hoster. That should be here any day now before the Labor Day weekend, so hopefully we'll see that. And this presentation with any questions or comments will be posted shortly as well. So again, any questions, please type in the right-hand column. I'm going to adjust some screen items here for some technical issues, and then we'll answer any questions you may have. Anyone with any other questions? Well, since there's no questions then at this point, I would thank everyone for joining. We appreciate your time today. Again, these programs are optional to attend. You're free to watch the programs live, else you can join into any of the recorded items there. But I thank everyone and have a wonderful day. Thank you for joining.